The CPI report, Child Protection in Iowa, is brought to you by Vocal, Victims of Child Abuse Laws. You can watch the program on Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. My telephone number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. This is the only 1-hour program per week that I know of that speaks specifically to the issues of child protection in Iowa. And we also look at other associated concerns like the courts that deal with child protection issues. And we realize that until the courts are straightened up, our relief in child protection issues may never get satisfied. We may never find out, we may never find the results that we're seeking in resolving child abuse cases until the courts give some attention to the United States Constitution, such things as the rule of law, such things as administrative rules that are set up to protect the family. If they're going to continuously overrule the rules, then every citizen is in great jeopardy. So I think that it behooves us to give some attention, even on this program, to some of the issues that plague us as we look into the area of child protection. We're not attorneys, so we cannot give advice like attorneys give advice, but we can steer you in the right direction based upon some of the things that we have seen and done with other families. We've seen some pretty tragic situations turned around, and sometimes just a hint from someone who's had the privilege of knowing what's going on, had some privilege of working with individuals who have suffered through some of the difficulties, we might be able to be of assistance to you as well. Well, what's happened in this past week? Well, one thing that happened that I thought was of a clear interest to me was that having been criminally charged for resisting the official acts of a deputy sheriff of Polk County, we found that the sheriff's office did not follow the rule of law. The rule of law says that when you commence a simple misdemeanor charge, you must file an affidavit. That's in the Iowa Constitution. It's also in the Iowa Rules of Court. It's also listed in the Ninth Circuit Court of Appeals, which references cases in the United States Supreme Court. It's also a requirement set forth by the Iowa Supreme Court in a case called Cedar Rapids versus Atkinson II. So it's covered by case law, it's covered by the Constitution, and it's a pretty well-founded piece of information that every judge and every prosecutor should know. And since it was brought up in the year 2000, city of Cedar Rapids versus Atkinson II, Uh, One would think that the message should have gotten around so that people who are going to charge other people, take them through a court process, uh, would have sense enough to know how to handle that process. The prosecutor's office in Polk County didn't obey the rule of law. Isn't it a shame that our public officials don't know enough about the rule of law, don't have enough caring about the rule of law, that they can completely ignore the rule of law? And I think it's rather tragic that these things are allowed to occur. At the same time, these people are asking for more and more money in order to run their offices, to run their illegal practices. Well, I was charged with 719.1, which is interference with official acts, and it's and resistance. I don't know what it was that I was supposed to have done to have frustrated a security guard at the Polk County Courthouse. By the way, the place is crawling with security guards now. Seems like everywhere you look, there's another security person in a courtroom. In one case, I saw 5 of them at the south door. That's the main entry for, since they shut down the people's house here, they have everybody coming through the south entrance, except employees and handicapped people who come through the west entrance. But they'll have as many as 5 at one entrance and 2 at another. And one of them was just roaming around the first floor. And they are also assigned to courtrooms. Sometimes they'll sit down in the courtrooms, and they are assigned to such things as bringing prisoners over from the jail to attend court sessions. Well, I had gone through a trial process before a jury. I appealed the jury verdict in that process, and I went to before an appeals judge who has dismissed the case. I haven't seen the paperwork on the dismissal as yet, but I'm taking his word for it, and it's on the record that he did indeed dismiss the case because no one bothered to check the rules of criminal procedure and do it correctly. Excuse me one moment. Sometimes that raspy throat overcomes me. But I'm pleased that that the court has seen fit to rule against the Polk County idiot who, working as a security guard, decided to lie and to scheme and to tell stories regarding my conduct in the courthouse, which was perfectly appropriate conduct pursuant to expanded media coverage because I take pictures in courtrooms. Well, we'll bring you a little more information as time goes on. But in the meantime, Don, we have a number of cases that come before the public courts all over the nation. I noticed that when someone is indicted for child abuse, it hits the headlines really big. Seldom ever, however, do the cases where there is a dismissal, do we read anything about the dismissal. Do you have a case from Lee Summit, Missouri, in which the case was dismissed for a person who has gone through the system many times, even though he was innocent? Don?
This is dated February 8th. Man acquitted in third child abuse trial. A jury acquitted a businessman in his third trial on charges he sexually abused his stepdaughter over a 3-year period. Here's a guy that went through 3 trials before he was finally acquitted. Theodore White, age 42, of Lee Summit, was cleared Monday of 12 charges, including statutory rape and statutory sodomy. Jurors deliberated about 2 hours. It was a wonderful feeling, White said when being released from jail, and I'm still living it right now. White was convicted in February 1999 of molesting his stepdaughter over 3 years, starting in 1995, when the girl was 10 years old. He fled to Costa Rica while awaiting sentencing, but was captured after the case was featured on the television's America's Most Wanted. He was returned to Missouri and sentenced to 50 years in prison. Well, I guess I can see why he'd want to flee this country if he was facing 50 years in prison. White was retried after the State Court of Appeals found that prosecutors did not reveal that a detective investigating the allegations had an affair with White's estranged wife. What a connection. What a setup on this guy that already spent time in prison. In a second trial, jurors failed to reach a unanimous verdict, and the judge declared a mistrial. Jurors who favored an acquittal cited a lack of physical evidence and inconsistent testimony by White's stepdaughter. Special Prosecutor Elizabeth Bach said she was disappointed by Monday's ruling. That's the attorney that prosecuted the case. She was disappointed by the Monday's ruling. I'm sure she was. Quote, "This is closure for our victim one way or another," she said. After 7 years, she needed closure. Well, that's one way to step out of the picture. Okay, John?
Okay. We're going to be looking at a videotape before very long here, given by Mary Nelson of the Iowa Department of Human Services, and she gives us an update on how it's going with all of the new bells and whistles they have on their system to protect children. But in the meantime, let's turn to our courthouse, our courtroom consultant, Terrance Walker. He has all kinds of things that he's been saving up for a presentation here on our wonderful courts and our wonderful judicial system. Terrance.
Okay, appreciate you having me on the show again. And it's funny how I can bump into people all over town here, and they'll ask me all the time and say, "Well, what are you guys talking about on the show?" Listen, okay, and I'll explain this for those that may feel that they are confused about what we're talking about. This is Vocal, Iowa. Vocal, Iowa is victims of child abuse laws. Um, Don and John obviously started this show. They discuss such bureaucratic agencies as the DHS and some of the other bureaucratic agencies and other court systems that get involved in abusing these so-called child abuse laws. I am the courthouse correspondent. I discuss related issues, though more focused on the judiciary. So there you have it. Some interesting things that I wanted to bring out. There was a couple of cases that transpired since the last time. I've been itching to bring these out, but we didn't have a show last week, so I've saved them for this week. About a week ago, the Iowa Court of Appeals affirmed a conviction of a clerk of court of Franklin County who left her tape recorder recording conversations of her co-workers while she was at lunch. They convicted her under a criminal statute penalizing eavesdropping by mechanical means. I thought this was just so bizarre. The woman's name is Carol Lee Philpott. You guys should look this case up. It's just so interesting and so bizarre. But the troubling part of the affirmance of the conviction is not so much. I mean, it might seem a little bit criminal for this lady to be recording conversations. She had always left her recorder recording, and she'd done so for about a year, according to the case file, according to the statement of the case. This happened back in 2002. I guess she had been recording the conversations or just leaving a tape recorder there because of some ongoing dispute with her coworkers for about a year before this. Um, I guess some of her coworkers took issue some November of 2002 with this and called the judge and said, well, you know, this tape recorder is still recording while she was at lunch. Called the Judge Carroll. He called the court administrator, and they charged her with this crime. Now, the troubling part about this is that, as discussed by the people, by the Judge Hecht, in the opinion that disagreed with the majority, he basically says, though the definition of eavesdropper means to listen secretly to what is said in private, the rest of the court basically, and this I'm paraphrasing what he said. He basically said the rest of the court ignored the title of the statute and the construction. So they're basically allowing these public officials, these clerk of court officials, to have some sort of expectation of privacy, and that was his beef, and that would be everyone's beef. Logically, that you cannot have a situation where there's public officials and in a public setting to be having some sort of private conversation, because there's no way that can happen. And one of the other interesting points I think that should be made, the United States Supreme Court in 1998, they basically said in the case of Alamendez Torres versus United States, they said the title of the statute and the heading of a section are tools available for resolution of a doubt about the meaning of the statute. I'm sorry, but Iowa Court of Appeals, you guys ignored this one and totally got this one wrong. This lady, she probably has lost her job by now, and it should not be so. And the way that they're construing this statute, if you have a tape recorder and you just happen to be recording in public and you happen to capture someone's conversation, that's a crime. So, citizens, you better be aware. The court's out to criminalize almost everything. A couple other cases. One I wanted to bring to light. We talked about this a couple weeks ago. I think you remember this one. You remember this one, John, about the guys who were telling jokes, lawyer jokes in the courthouse?
Right.
Yeah, these guys basically were saying, how do you tell when a lawyer is lying? And they were, these are older guys. They were members of the Americans for Legal Reform, and they were just telling jokes in the court, outside the courthouse, actually. The surprising thing is they were just saying stuff like, how do you tell when a lawyer is lying? And the other one says, well, his lips are moving. And they laughed and giggled. One guy had apparently went in and complained, and they were arrested for disorderly conduct. Well, guess what? They've got exonerated, and I'm glad that you've got exonerated too. The thing I'm still wondering, I'm curious of, is if we didn't have this show, this forum to discuss these sort of issues, I wonder if you would have really been exonerated. What do you think about that, John?
I think you're right. I think it does have some impact. People are listening. They're not paying any attention, but they're listening.
Exactly. And these guys had raised so much a stink online. I'm sure they did so in the local media too. That case was reported by the AP nationwide. I think that's the only reason why they got their case exonerated. Because I've seen many situations where that wasn't the case, where there was no publicity, and basically the guy got railroaded, or the lady got railroaded, whoever was also convicted. And you probably wonder why I got on my shirt today, aren't you, John?
No,
I don't know
yeah.
if you see that?
Yeah, that's okay.
There we go. I didn't wear my normal formal attire for the show, but as you can see, I got my man Ice-T on the shirt. Original gangster. I thought about taking it off, putting on a suit and tie, coming over here. But I said, you know what? This is so related to the show, the topic I want to cover. I think I'll leave it on. You know, because we've got a lot of gangsters that are in black that are on the bench, uh, and those I think those guys have something on Ice-T. Even so, here's one case I
Do you
wanted to
want to
bring up.
tell us a little bit about Ice-T for those that don't know
Well,
Ice-T?
Ice-T is the man. I mean, he's the originator of crime rhyme. He called it. You know, he'd call it crime rhyme, but uh, he also termed himself as an OG, which is terminology for one of the older gangsters. But you know, he was one of the originators. But the funny thing is, I wanted to draw a parallel because we've got a lot of gangsters in the court systems, you know, and you think about that, you know, they're not doing anything like robbing people or anything like that, but on a different level,
They're giving inattention to the law, aren't they?
they're robbing us of our rights.
That's right.
And one of the things I wanted to point out, they use what I term judicial technologies to to inflict their gangsterism on us. Uh, you know, they do that in a variety of ways. One way they do it, and I'm sure you can relate to this. They duck issues. That's one way that they do it. You bring a valid point, just like you brought your valid point that your complaint in your case, and you've never been convicted of any crime until this, but now you're exonerated. But I wanted to bring that out, you know, just so people don't think that you're a hoodlum on TV here. Uh, but the funny thing is that you brought that issue up in that case that the guy did not swear an oath on his complaint, and how many judges ducked that issue?
Three
There
judges
you go.
and one
That's
prosecutor,
judicial.
4 members of the bar refused to listen to the complaints, and they were well put before the court.
You cited the law.
Yep, and they had every opportunity to redeem themselves, and they refused to do so.
There you have it. That's a judicial uh, gangsterism right there.
So would you
Um,
encourage other people to check their documents,
Check your
John?
documents.
Correct.
Oh, I thought you was asking me.
No.
Either way.
Check.
One of the other things I wanted to say is that they also, one of the other ways they gangsterize you is that they try to confound your tongue. You could be arguing that, well, hey, this guy is didn't swear an oath on the affidavit. Well, they'll reword whatever you're saying and to make it seem like you said something totally different, so that they can argue against you. So there you have it. That's two methods. Method number 3, killing you. I call it killing you softly. You know, they'll be really, really nice to you and say, "Oh, well, it's nice that you're representing yourself, and you're doing a really great job, and we appreciate you filing, and you break some great points. We appreciate you, Mr. Harvey, bringing this to the attention, and you have, like Mr. Judge, Prosecutor Justice Allen. Oh, you did a really great job on your brief, and come time for decision time, you are." You don't know what you're talking about, and we're going to duck your issue. We're going to confound your tongue, and we're going to just rule against you, and you're not going to be able to do anything about it unless you have a show. So, a word to the wise: you better get out here and get on the show if you want to get some justice, because
That's right.
you're not going to get any justice if you don't have any publicity. Because I'm telling you, judicial gangsterism is in effect. One of the last ways that I wanted to say that they use these judicial gangsterism technologies, they feign confusion. And when I say they feign confusion, I mean they act like they're confused. If you raise a valid point, they'll act like they're confused. Well, I don't know what you're saying, Mr. Harvey. Can you rephrase that?
Or just let's go on, Your Honor.
Yeah.
I don't understand it. Let's go on.
So there you have it. There's 4 ways that they use to actually inflict their will upon the citizenry. And a lot of you, I hope this is enlightening for you. So beware. So when you see it, you'll be able to to not only um, identify it, but you'll also be able to counter it. And like I said, the best way to counter it is with publicity. Um, did you want me to go ahead and talk about some of these other stories that I have here?
We've got about a minute,
Yeah, we're
but
about okay. I just wanted to bring up one other issue. The Bettendorf lawyer. There was a Bettendorf lawyer here that actually got she got barred by continuing public offender work for singing, what they say, and this is in the Des Moines Register today, February 9th. Sally Machetta of Bettendorf, 500 cases, court-appointed defender, 150 as a privately retained lawyer. According to this article, she complained a couple of the judges in the area where she works. Guess what? Judicial gangsterism once again is in effect. She got basically barred for doing any more work for the public defender's office, and that comes back to a rule, an ethical rule that is going to be placed into effect here by the Iowa Supreme Court. Rule 8.2, judicial and legal officials. To maintain the fair and independent administration of justice, lawyers are encouraged to continue traditional efforts to defend judges and courts unjustly criticized. Well, we don't know if the judges were justly or unjustly criticized, but it seems to be a presumption within the judiciary that anything that a lawyer says against a judge is unjust. Therefore, we're going to bar you, and so therefore you're going to serve as an example to all the other lawyers out there. Don't expose a racket, because we are the original gangsters.
We'll bring the original gangster, okay, on the screen there. Okay. Hey, thank you for those stories, and would you put those others aside, because we'll see to it that you bring those on future programs. We need to know the kinds of things that you've been looking into in the court system.
Yep.
For right now, we're going to move to the Hoover Building, and we're going to hear from Mary Nelson, who's going to tell us the marvelous things that are happening with respect to their expansion of their influence, and the marvelous things that they're doing for families in Iowa. They're really kicking in and telling the legislators all about these things that for which they will need bigger and bigger budgets, because they're going into community care, they're going into all kinds of things. So with that comment in mind here, let's listen to Mary Nelson. She's one of the top officials of the Department of Human Services, and here's what she has to say to the department's council. These are individuals who volunteer their time to do policy making for the Department of Human Services. Here now, Mary Nelson. We'll see what she has to say in the report.
Okay, this is an update on the child welfare redesign. I'm just going to highlight a few of the things where there's some current activity going on. I'll wait till everybody gets one. I'm going to work off the PowerPoint and then just reference the TAN document. And just to anchor again the redesign, starting with page 2, is where we've really focused on is being clear about who we serve and looking at making sure we have, we're clear about our outcomes, and then looking at how do we improve our practice. And one of the things that we'll talk about today is we've been really working on more of a differential response, being making sure that the response we have for the kids and families we serve is based on the kind of risk level that they bring to us, and so that our response differentiates based on the level of risk. The circles on page 3 sort of kind of a conceptual framework we've been using around a lot of how we're trying to both differentiate services and really strengthen our practice across our system. In that we have the family is in the center of the work we do, and where our outcomes are focused. But one of the big things that we're trying to do in the redesign is really strengthen those inner circles. So look at, for families that are lower risk, how can we do a better job partnering with the community to build a strong sense of use the extended family, the informal supports, the friends, the groups in the community like faith-based groups, neighborhood organizations, support groups, to really, as a whole, strengthen the kids and families in our communities. And then really in that outer circle, where we have the more formal systems like the child welfare system or the juvenile justice system, really that's where our kids with the highest risks, where we open cases and provide services. But again, throughout our practice, we're also partnering with the communities so that we can build up the supports around vulnerable families so that they don't necessarily need our services. And Kevin talked about our community partnership. That's really a big piece of that, is that strengthening that inner circle and building those kinds of supports for kids and families in their own community and engaging everyone in the community around keeping kids safe. So if you look at the page 4, what I'm going to focus on today is some of the things that we're doing around strengthening our practice. And again, that is both strengthening our partnerships at the community level and building up the capacity of those inner circles to support kids and families, and then strengthening the practice of our own agency for the cases that we open. And the italicized items are just the ones that I'm going to talk about today, because they're the parts of the redesign we've been doing the most work on in the last several months. And community care is where I'll start. And I think about a couple months ago, I came and talked just briefly about community care, but at that time the RFP was still out on the street. We did receive responses and have selected a contractor. Just again, start out with the goal. For community care is the initiative that's new for us that is really designed to serve our lower risk kids and families, and to strengthen those families so that we reduce child abuse and neglect. And again, it's through the provision of community-based services. And it's really got overall two purposes. One, as I said, is to really strengthen those families and reduce the abuse and neglect for them. But the other piece is allow our staff to focus on the highest risk cases. Because, and we've been talking about this really since last June, that we really wanted to make sure that, given the limited resources we have in the high caseloads, that we only opened cases and assigned our caseworkers to families where the risk was highest, and really use the community and develop community capacity for those lower risks. So this is really our opportunity to do that. Our major strategy is we put out the RFP and we have a single statewide performance-based contract, and I'll talk a little bit more about some aspects of that. But we really wanted a statewide contract so that we could ensure that there were services everywhere in the state, that kids in rural and urban had equitable access to the kinds of services that would be available through community care. And one of the things we heard a lot in the redesign was, as we did the listening phase and worked with our stakeholder groups, was people really wanted us to look at giving our providers more flexibility to deliver the services. And this is really one of our first attempts to really maximize the kind of the flexibility that our private agency or that the provider has in delivering services, but hold them accountable for performance. And so we're moving from buying units of services and starting to move towards where we're really purchasing outcomes. That a portion of the payment actually is dependent on achieving positive outcomes for the kids and families. The contractor we selected was Mid-Iowa Family Therapy. They're home-based out of Perry, Iowa, and then they have branch offices across the state, and they also have, in their proposal, they have some subcontracts, and they'll be establishing additional ones, but other partners that will be part of the community care network. Going back again to community care, what it is really child and family focused services and supports, and it's designed to keep kids safe, keep the family intact so that they prevent the need for further involvement with DHS. And when I go over that's really where our performance measures are targeted, around those overall purposes, making sure that kids don't experience abuse or neglect, and that those kids don't have to come under the jurisdiction of the juvenile court. And a big emphasis around this is that the Mid-Iowa and its subcontractors will particularly focus on connecting families to existing services and supports available in their community. Not, in many cases that might be non-traditional, again, like the faith community. And it may be connecting them with existing services, like getting them hooked up with accessing food stamps or accessing other kinds of services funded through the United Way. So they may provide some services themselves, but a lot of what they will do will help families link up with the services that are already available in their own communities. And that one of the reasons we believe that's really important is because in the long run, the formal system comes in and out of people's lives, but we're only really there for a few, in the long term. You think of 18 years of raising a child, we're there for a few months. What we really want to see this contractor do is connect people to connect our families to their community that is there for the long term. And so it's more of a resource to them if they find themselves having some difficulty. Again, they've got connections in their community rather than becoming dependent on the formal system. The eligibility criteria for community care are on page 7. And as I said, these are our more moderate, low to moderate risk families. The child must fall into one of two criteria. They've either been, in the front door is always a child abuse assessment. So they've had a child abuse assessment, and either it's been not confirmed or confirmed not founded. So it's not been a serious. If it has been confirmed, it wasn't a serious level of abuse. And our assessment determines that there is a moderate to high risk of future abuse. So what happened may not have been that serious, or we may say abuse didn't happen at all, but we see risk factors related to future abuse. Or for older kids, there has been perhaps a more serious incident, but the future risk looks lower. Though if the child fits either, or the child and family fit either of those criteria, they can. Then we look at does the worker and the family identify that a referral to community services that would be needed, that there is some need in the family that community care could address. And then the family has to agree to participate voluntarily in services. And that's because these are cases we would not be able to take to juvenile court. These don't normally, they would not meet the criteria to take a case to juvenile court, so it's important that the family agree to participate voluntarily. If the child and family, after the assessment, we go through these and we find that they're appropriate for a community care referral, we'll actually have them sign a voluntary release, and then we'll give their name to Mid-Iowa Family Therapy, and then they would reach out to the family to see if they're interested, to pursue their interest in services. Our expectations of the contractor, that they have to work with a wide range of kids and families that come to our attention, including families that have limited English proficiency. They have to do an assessment of what the child's needs are, how the family is functioning, and what the risk issues are. They have to be available 24/7 to respond to crises. They're expected to connect families to community resources, and then to have put in place a referral network that is available and convenient to families. And we actually signed the contract January 31st. And then they have, during this month, they are really building their community network and getting their program into place, and referrals will actually begin March 1. So we've got this month for them to build up and make sure they have this referral network in place. Page 9 is the performance targets. And the way the community care contractor is paid is they will, a portion of their payment, about 85% of their payment, will come in monthly fixed amounts. That will pay them, but 15% of their payment they earn only if they meet these targets, and we'll do those. We'll review these monthly. The first is that 5% or less of the families that we refer will have a child adjudicated China and DHS ordered to provide services within 6 months. So at least 95% of the families that we refer to them will not come through a China adjudication, not need to have an adjudication. Similarly, at least 95% of the families will not have confirmed or founded reported abuse or neglect within months after referral. So a maximum of 5% would actually have an abuse incident that is confirmed. They're also expected to make contact with all the families that are referred for services, and at least 80% they have to have a response back within 14 days of referral. The reason we put that performance standard in is we really wanted to encourage them to reach out to families and not to triage so much that they only, that they sort of write some families off. We wanted to really make sure that they are pushing heavy on family engagement, which is what this is designed to measure. And then we have a consumer satisfaction measure. At least 85% of the families have to respond or have to have positive response in terms of the access they felt they had to services, the convenience of receiving services, how helpful the contractor was, and the degree to which the services benefited them. And they're putting together a consumer satisfaction survey. We actually have to approve it. And then we will analyze the data. So they'll provide the survey to the families, but the surveys will come back to us so that we can then analyze the data, sort of to make sure that there's real impartiality in that. In terms of our timeline, as I said, we signed the contract on January 31st. We're doing training in the next 2 weeks for our staff about how community care will work and how they'll make referrals. And then referrals will begin on March 1. And then we have monthly meetings that we've created a community care advisory team of DHS staff across the agency, and we'll be meeting monthly with the contractor to review their performance, review how how is community care going, because just to make sure that real early on, if there are any issues, we're getting this back on track and monitoring it closely. This is probably for us one of the most exciting aspects, I think, of the redesign. It really embodies a lot of our principles in terms of really wanting to move towards family-centered services that are very community-based and use more informal services and supports for families. It's our first real performance-based contract, and it really moves us towards, again, the differential response, focusing us on the more serious cases and creating alternatives for less serious cases. So we're very excited. I really hope we can come back to you after a few months and kind of give you an update on how this is going, how this is actually rolling out. So that's community care.
Mary?
Yes.
Would there be a chance that county CPCs would be involved in this at all?
I could envision a couple of ways that county CPCs, because our expectation of the contractor is that they reach out to the people in the community that they need to and make the connections that they need to. Some of the families that they may encounter, there may be adult mental health issues in the family where they would want to connect with the community, with the CPC. For some of the older kids, it's possible that if we refer a child that is 16, 17, they may want to make sure that good transition's going on. Now, these wouldn't be foster kids, but might be kids that are looking at transition through the educational system.
I thought that might enter in.
And that's a really good point. As we work with the contractor, we'll make sure that they are thinking, look at who they're connecting with and make sure that suggest to them that they make sure that they're touching base with the CPCs. I'm meeting this Friday afternoon with the contractor, so I'll make sure to mention that would be a good connection to have in place. Similarly, that because it's very important that they have good working relationships. The next piece is our child welfare model of practice, and that is the TAN handout. This is a piece that staff, and Kevin mentioned our staff are being trained. They've been in training last month and this month. We're doing sessions across the state, I think 3 to 4 sessions a week in different parts of the state related to our child welfare model of practice and then the aligning documentation with practice. This is a product that we have worked on throughout the last several months, last year or so in the redesign. And it is really, the goal of this was to really take the department's guiding principles, the critical outcomes that we have for child welfare, and then really look at how do those play out in practice, and to have a common framework that we would all be working from, that we would be clear around with our frontline staff about what it means, what our expectations are, and how we want to practice with families. Things like, again, emphasizing, if you skim through there, you'll see things like family engagement is emphasized, in being part of a team with the family, collaboration, bringing together all the people that are involved with the family as part of a single team, using extended family and other informal supports, making sure if we have to place kids outside their home that we're using relatives, that we're keeping siblings together. So it's really taking the values and taking through the life of the case. How do those values play out, and what do we hope to see? The other piece that you see in the model of practice is we also then went and or spent some time articulating what does that mean organizationally for us? What kinds of supports need to be in place for staff and supervisors if we really want frontline practice to be family-centered, and we really want to engage with our partners? Then how do we need to behave in the things that Kevin and I do, and that what are the implications for training, for supervision, for our quality assurance, and for how we lead the agency. I participated in some of our staff training yesterday. The training is going on yesterday and today. And one of the things that we did was take this model of practice and break us down into small groups, and then take pieces of it and this is mainly frontline staff, but then talking about what do we think is really important about this, what does it mean for us, how close do we think we are to this, what are the challenges of doing this kind of practice. And it was really a very exciting conversation with staff. I think one of the things that we're hearing, the comments we're getting back from some of in the feedback from the training, is around the staff feeling really positive about having a clear sense that this is what our framework is. This is what we espouse about how we want to practice, and having that be common across the state and really embody the values that we say are important. The second piece of that training, as I said, has been following along on, or if you're following along, this would be slide 12, but is this piece then about aligning documentation with practice. Early on, we talked a lot about streamlining our documentation, and we engaged a contractor, the Center for the Support of Families, to help us with that. And one of the first things that they did was reframe the conversation and move us away from solely focusing on streamlining documentation and focusing more on aligning documentation with our practice. And a byproduct is that you streamline it, but that what we really needed to make sure was that our model of practice was solid, and then that the documentation we required of our staff really followed the life of the case and looked at what information do you need when, so that you have the right information at the right time to help staff make the right decisions. And that's really what our focus then on aligning documentation with practice has been about, so that workers collect things when they need them, and then they continue to use that information. That information is available for use as they make, and helps inform the decisions that they make. So we're not collecting information that we don't use, but we're also making sure we collect the right information early when it's easy to collect, and then make it available when the worker needs it. So we've been focusing on things like really making sure that we have that we've looked at the kinds of decisions that staff make as they work and across the life of the case. And by that I mean from the moment you come in contact with the family at intake on through the assessment, the provision of services, and then case closure. Looking at handoffs, making sure that if a case moves from one worker to another, that the second worker doesn't have to start all over, that the work and the documentation that the first worker's done is available to the second worker. One of the things they've created, for example, is a life of the case summary, so that there's one relatively succinct document that is maintained in a file and updated as we work with the family that has all the critical information in it. So that if I hand you a case, you don't have to look through the whole volume of the case to try and understand when did we first get involved with this family and what have been our significant involvements. Otherwise, that's hours of a new worker's, as the frontline child protection investigator hands off to the ongoing worker, that's a lot of hours they have to spend, or if it changes worker because one worker leaves and I'm the new worker. Now, that will all be in one simple place that I can see, here's when we first got involved, here's what we've been involved, here's the services this child and family have received, here's how our agency's been worked with this family. Other things we're doing are around automation. Right now, our staff have to enter much of the same information, like the child's name and address, date of birth, over and over and over. One of the things that the tools we're working on is once that's in the system, if I have to create a new form, it will, they call it auto-populate. All that information that's already in our data system will appear on the form.
You've been viewing a presentation by Mary Nelson, an official of the Department of Human Services, regarding some new practices engaged in by the Department of Human Services, an extension of their current services to cover community care services. These are to families who would not otherwise be involved because of child abuse charges, but it's an attempt of DHS to expand the scope of its practice, and they're going to be spending lots and lots of money. Any comment on that, Terrance and Don?
Well, I guess I would, one concern I have is how are they going to farm all this out? I listened briefly on her comments here. She's rambling on that link there. But I know you were there. What were the plans? How are they going to farm that out? I mean, is that an increase in their budget? Farming all this stuff out?
That part I don't have an answer to, but I do know that it's out under contract, and it's something like 600 families that they're thinking about covering under this. And I think the payments are going out like $159,000 a month to the contractor in Perry who took on this task. And so they'll be making referrals to this contractor.
We made reference to that in a previous program.
Correct. Correct.
Wow.
So it's rather interesting to see that at a time when they're struggling with budgets and staff, they're talking about expanding. And this is supposed to be better results for children. And I don't think that the voluntary nature of this system is quite as voluntary as they would like to make us believe. Because if they can hang something over your head, voluntary becomes mandatory. And
Compulsory, huh?
Or compulsory. Right, right. So this is what Mary is explaining to the members of the General Assembly and others. In this case, it's the Council for the Department of Human Services. But she's explaining in detail just how they're going to go about all these things. And they're going to be able to chew out this contractor if he doesn't perform in accordance with what they want. Now, the department people, they haven't been able to perform this way, but now they put it out to contract, and the contractor has to perform, or otherwise he doesn't get paid.
So they're putting themselves in the roles of the people that analyze whether or not they're doing their job, when in fact they have been shown at times not to do their job.
That's right. So they become now the critic.
Okay.
But the bottom line is the child is no longer in the home, and the parents are hoping to get the child back in the home.
No, not necessarily. No, in this case, the child would be in the home because there's been no child abuse cases lodged against them. So
I really think that's interesting, how they're going to farm it out. I mean, is this a money saving?
They've never said anything about saving money.
Well, it must not be.
And forbid it that anybody should ever think that the Department of Human Services would come up with a scheme to save money.
So if the parents aren't abusing their children, why are they involved in this system then?
A good question. I wish you had a good answer for that, Don.
And where was that confirmed but not founded? They said if there was
There's
How
no such
can-
thing. There's
how
no such
can,
thing as confirmed and not founded.
How can a child abuse allegation be confirmed but not founded? That's dumbfounded.
Dumbfounded.
That's
Not
a dumbfounded.
put on the registry, isn't that what it means, John?
It's probably confirmed but not registered, and that is only for physical abuse, where the abuse is a one-time situation, and they don't want to have to mess with one-time situations, so they'll confirm it, but they won't put it on the registry.
I think this is just another case of big government. Wouldn't you say?
Big government, yes,
Correct.
that's correct. Yeah.
They make their money.
Big government contracting out to big firms,
That's right.
so
It's-
they can all make big money.
And the legislature will continue to pump out money to it. Don't you hear the children crying?
And they're picking up these schemes from all over the United States. You know, some place in the United States has been picked up some practice, and they want to copy that practice. And they'll go to North Carolina and pick up a practice there. They go to Milwaukee, pick up a practice there. They have an expert from Florida, and they may have a practice. By the way, the Florida people don't seem to have a real good handle on taking care of their foster care programs. Seem like to me the children are dying down there in Florida for some reason because of lack of responsibility.
I really don't understand, or did they? She didn't really put forth any money figures, so I know that wasn't a selling point.
No.
And then she never did put forth any quantitative data, or qualitative data, saying how better this sort of mechanism would work. So I mean, to me, she hasn't really sold me. I do sales, and those are the two key things that I would ask if I was going to buy. And I
Right.
guess we're buying it anyway because we're taxpayers, right, Don?
That's correct. You
You
don't
wanna
have.
give her a minute of our time as we're wrapping up the program?
We'll let her finish up here for us.
They can go buy it. And we've been, this month, we're training our staff on how to use these credit cards. Each office.
But
will
in
have
the
one or
meantime,
two
we'll
people
thank our courtroom consultant here, Terrance Walker. Thank you
One of
for
the things we wanted to- we've been
stepping
very
in and
careful about is making sure that
assisting
we
and
have
bringing
good
us
policy.
some valuable
We wanna make it
information.
flexible
And we're
so
looking
it's
forward to
user-friendly for staff,
your
but also
return to
for
finish off some of these other stories that you've already collected.
In developing that particular one, we looked at what Department of Natural Resources have done. They've been using procurement cards, and they've passed several audits in terms of how they've used that. So we modeled our protocols because they found it both useful, but also they've been able to be accountable. So we really looked at what they put in place so we could learn from their experiences. Then the last thing is something we called eyes and ears supervision. And I think the rule for that may have come to you today or last, I think maybe today or last month or, yeah, I think because it's, and this is, currently and the way our rules are right now, we don't, we only allow staff to buy supervision from a private agency if they're also buying therapy, which means that sometimes what we just need is supervision. We need eyes and ears. And so one of the things we're doing is delinking those. So if we just need an agency to go out and make sure that things are okay, we can pay them for that without also having to pay them for therapy. It was sort of like whether the family needed it or not, we had to buy the therapy, which was both, in some respects, wasteful and just, again, not individualizing services. We're currently, in terms of next steps, we've got a set of
Thank you
draft
for
rules.
tuning in to the
We've got
CPI report. See you
providers to take a
next
look at.
week.